All right, everyone, welcome. Thank you for coming today. Happy to have you with us as we are doing part one of a three-part follow-up on the architectural review presentation that I did last month. So pleased to see so many of you joining with us today. The plan today is to do shorter than last time, to only go 30 to 45 minutes. And I'm happy to answer questions along the way. But I wanted to break it into three smaller chunks. One, so that I don't hit you all with a fire hose of information, and two, to break it apart in areas that I think are easy to look at for architectural review. And so today we're going to talk about the process, how the process works, and work through that. Next time, we're going to talk about drafting architectural guidelines and standards. And then the third one will be about enforcement. So that's how I think breaking it up makes the most sense. And so we'll start today with the process. So let me share my screen. I'm going to see if I can get this to work. All right, are you all seeing this? Hopefully, okay. I'm
Yes.
doing it on dual screen, so
Yes, we are. I am at least.
there we go. All right, you still able to see it? Okay, very good. So this is a slide from the presentation that I had back in May, and it talks about the typical process. And if you have questions, just put them in the chat. Audrey, if you will, because I've got the presentation up, I'm not seeing the chat questions, so I'll have you jump in if there are questions about this along the way. But this is a typical process for architectural review. First of all, you have an ARC committee. Again, remember that can be under a bunch of different names. It might be design review, it might be architectural control, architectural review, sometimes architectural committee, a number of different names. I use ARC just because it flows off my tongue easier. So architectural review committees nominated by the board. That's how most of your documents are written. Not all of them, but most of them are written that way. And it starts with the declarant. So while the declarant is in control, the declarant can appoint the architectural review committee members. And then once the declarant is gone, it happens with the board. Now, what happens if you can't get people to serve on the architectural review committee, or you can't get enough? Maybe your documents say a committee of 3 or no fewer than 3 or something like that, and you can't get enough people. Well, the answer is if you don't get any, then the board takes it over, and the board is also assuming the role of the ARC. If you have 1 or 2, but fewer than the minimum that you're supposed to have, then you run with what you have. Now, I don't recommend having a single person ARC. That's a recipe for disaster. But if you want, maybe one board member also serves on the ARC, and that's their only responsibility, because it can be a heavy load depending on the community. Some communities it's not heavy at all. In others, it's really big. And so you have a board member that serves on there. Whether it's the committee as the committee chair or not is irrelevant. Some documents allow you to bring in outsiders for pay, architects, engineers, things like that. So it's really document driven, but that's the process for getting the ARC put together and have the people you need in place to review applications from owners. And one question that I always get asked in the process is are meetings of the committee open? And your documents open to owners or open to the people that submit the application, either way? And the answer is usually it's driven by your documents, but oftentimes documents are silent. They don't say that they have to be open. If there's a general provision in your documents that says all committee meetings have to be open, that would include the ARC. But again, that's not a typical provision. That's pretty rare provision. So most of the time, as long as you don't have a quorum of the board sitting on the ARC, the meetings do not have to be open to either the homeowners or to the person who submitted the application. If you have a single board member on there, the same rule applies. But if you have a quorum of the board, depending on the size of your board, you have a quorum of the board serving as the ARC, then those meetings have to be open. And then certainly in those situations where the board has taken over the ARC powers or ARC responsibilities, those meetings are board meetings. Even though it may be limited to architectural review applications only, it's still a board meeting, and so it must be open to all homeowners. So with that background, let's kind of jump into the process. And I'm going to back out of this for just a second. I'll come back to the slideshow, but I want to bring up another document. If I can do it. My apologies, this is taking longer than it should. Okay, I'm going to stop sharing for a minute and I'm going to do it the old-fashioned way. Okay. Let's try this. Y'all are seeing this one now, this language.
Sure.
Okay. So this is a detailed architectural review committee provision in a set of documents that I was looking at even just this morning. Now, I have removed all incriminating names of the association and the county that they're in. I've changed both of them now. It says Deschutes County. It's not really a Deschutes County Association. And it's not really the ABC Homeowners Association, which you'll see up here. But it is a pretty detailed architectural review committee provision. Your documents may not have as much detail, and that's okay. We live with what we've got. This one says, notice in the first sentence, it says improvements on the property shall be made in conformity with the ABC subdivision design guidelines and project documents. So it's already assuming that you have design guidelines, and then it refers back to project documents, so the declaration and the bylaws. Next sentence is one that you often see starting an architectural review committee provision. It says no improvement shall be commenced, erected, placed, or altered on any lot until the construction plans and specifications showing the nature, shape, height, materials, colors, and proposed location of the improvement have been submitted to and improved in writing by the ARC. Now, a couple of things about these first two sentences that I want to point out. One, notice that improvements is capitalized. That's not always the case in all governing documents. It's nice when it is because that means it's a defined term. And you can go up into the definitions and figure out what it means. And does that include landscaping? Does it include exterior, elements? All exterior elements or just some of them? What is included in the definition of improvement? So that's helpful if you define what an improvement is, because that means that nothing that's an improvement can be built or altered on the property until you get the plans. Then another thing that is key in this process is that it says you have to provide plans and specifications showing all of these different elements. Now, sometimes an element may not come into play, right? So let's say I'm painting my house and I'm just repainting it the same color that it is now. Well, the height's not going to matter to all of that because there's nothing that really applies. So you have to look at each one of these characteristics separately, but it's given you the breadth of what the ARC is doing. Now, the next sentence, often a standard one, is this declaration serves as the authority for the ARC to use its judgment to see that all improvements conform and harmonize as to the external design, quality and type of construction, architectural character, materials, color, location on the building envelope, height, grade, and finish, ground elevation, natural conditions, landscaping, and all aesthetic considerations as set forth in the project documents. The reason I like this provision is it gives the board, or if it's acting as the ARC, or the ARC as a standalone, great discretion and great wiggle room for dealing with each application on an individual basis. It's your great protection. And you may recall that in our May presentation, I talked about, briefly touched on a case that I had that dealt with a retaining wall and a fence. And in that case, the court deferred to the board. In that case, the board was acting as the ARC, deferred to the board because the board had considered these characteristics. And there's another case actually out of Deschutes County that's a view case. They built a home looking for the view, and the Deschutes County Circuit Court and then the Court of Appeals deferred to the Architectural Review Committee based on the discretion because they had properly considered all of their characteristics. Now, what that means is, in very, very plain terms, is that the court says it's not substituting its own judgment for the Architectural Review Committee. They don't like doing that. They do it sometimes. If you don't go through the process and you don't consider the proper characteristics, then the courts will say you didn't do it right. We're substituting our judgment for yours, and because you got it wrong. But if you go through the process, even if the court thinks you got it wrong, came to the wrong ultimate decision, if you go through the process and consider the right things, they're not going to substitute their judgment for you. And that is a very important thing. So as we look at this provision, you know, there are these things that you need to look at, and you're going to have a similar provision in your documents. It may not be as extensive, but you should have something. And if you don't have anything, then that's where you probably should give me a call and say, hey, Chris, do we need to amend to add some of this in to give us greater protection? And we can have that conversation. But you want something that gives you that discretion and protection. Now, here's another thing that I want to talk to you about. Down here, the last couple of sentences here in this, it says the procedure and specific requirements for review and approval of construction shall be set forth in design guidelines and standards adopted from time to time by the ARC. The ARC shall not be responsible for determining compliance with structural and building codes, solar ordinances, zoning codes, or other governmental regulations, all of which are the applicant's responsibility. And then the provisions of this article shall apply in all instances in which this declaration requires the ARC's consent. Okay, so here what it's saying is the procedures are going to be set out in the design guidelines, and that is common, and that's my preferred way to do it. Now, sometimes you will find a declaration that has the process and it just makes for a longer declaration. There's nothing wrong with that, but I like the ability of the ARC to adopt design guidelines. And the reason for that is things change over time. You learn from mistakes, and it's so much easier. And you learn from good experiences too, by the way, not just mistakes, but it gives you the opportunity to look at it and change as the circumstances change, and it doesn't require an owner vote to amend the declaration, which is often very difficult, if not impossible to get. If it's in design guidelines, the board can do it, and it makes it much easier. So what happens? What's the process? Well, owner makes an application, and with that application, typically you require plans and specifications to be submitted. As we showed up here, construction plans and specifications showing these details, you got to get it. And they submit it. Now, most sets of documents says, and I've skipped down in this language, it'll say something like, the ARC shall consider and shall look at it. And here you see the ARC has the power to hire an architect to assist. And then you can set fees if you need to in detailed plans. And then the key is often a decision provision like this one, which says the ARC shall render a written decision approving or denying the application, or it says you can ask for an extension, but you don't have to consider it until you have all your materials. So there is typically language like that in here. This one, the breadth of it's not quite as good, but the idea is that they submit an application and the ARC can request missing information if they don't submit everything that they're supposed to, or it may request an extension if it needs to consult experts or for any other purpose to look at it and to weigh the application. Now, many ARC provisions have something like this, which says after you've received all the materials, you have 30 or 60 or 45, I've even seen as few as 15 calendar days to approve it. And if you fail to approve it, then right here, the application shall be deemed approved. And those are very scary provisions, because if you're not paying attention, then things get approved that maybe otherwise would not get approved. So here in this provision, it says the ARC shall be entitled to establish one or more extensions of time not to exceed 30 days, which is nice. It's nice to have something like that. And so that's a good thing. Now, one of the things that I do when I amend these provisions is I like to get rid of this deemed approved language. And I like to say, hey, the board has 60 days to approve it. And if within 60 days they haven't approved it, they've got to show good cause as to why it's not approved. And if they can't show that, then, and it's not approved within 75 days, then it's deemed approved. So there are a couple of different markers there. The 60-day marker, it's like, okay, they've got to provide evidence as to why they haven't approved it yet. And then it gives them just a little bit more time to approve it, and then the deemed approved comes in. But it's just not automatic. There's a step in between, which is why I like it. So again, application comes in, board has the opportunity to review it to make sure that everything is there. If it's not there, they go back to the owner and say, you have to submit this, and this. We need these things. And then they can hire experts, an architect, an engineer, as the case may be, to work through the process with them. They also have the ability to get an extension of time if they're coming up on their deadline. Again, this all depends on your documents. Your documents may not have all of this. And if it doesn't, you may want to consider amending to give you greater protections. And then there is often a drop dead date. They have to make a decision by such and such a date, within 30 days, within 60 days. And frequently, although not always, there is a provision that says if you don't do it within that time, it's deemed approved. Now, how does this review work? A lot of people will say, hey, can we just do it by email? And you can. I'm not a fan of that. The reason I'm not a fan of that is because I think it's a problem in those situations where it's never a problem until it becomes a problem, right? When somebody gets upset and they don't like the decision and they want to fight it, and they end up taking you to court. And when they take you to court, the court's going to look at the entirety of the process and see if you followed everything that you were supposed to do. And those emails and everything that's in them, good, bad, and indifferent, is going to be part of the discovery process. And so I'm not as big of a fan of doing it via email. I prefer that the ARC meet in person, uh, and I'm also a fan of allowing the homeowner to be part of that discussion in person. But here in these documents, that's not required. But but I am a fan of that nonetheless because I think the owner ought to be able to see where the deliberation's going. I think the ARC decisions ought to be more of a collaborative process, and I recognize that takes time and it's difficult. But when you do that, courts like that because it shows that you're engaged. It shows that um, you are involved with the homeowner in working through the decision. And courts are big fans of making that uh, process as interactive and as engaged as possible. In fact, again, just going back to the lawsuit that I was telling you about, that very thing was one of the factors that the court liked um, in the whole process. Is the board president came out and met with the homeowner and walked the property and talked through everything. And so that that's really how it works. So the owner makes the application. The application includes all of the things that they're supposed to require. Our committee meets with them. They have to make a decision within a certain period of time. Again, they ought to do it in meet with the homeowner. And then the key is to issue a written approval or deny, a written approval or a written denial. Either way, you ought to issue it in writing. And the approval can be with some conditions or stipulations. So, for example, we approve it upon the condition that you use a Sherwin-Williams paint as opposed to a Benjamin Moore paint. Maybe they submitted a Benjamin Moore paint chip instead of a Sherwin-Williams paint chip, and you only allow Sherwin-Williams. Maybe it is approval with a condition that you show an architect's report that this material is a good substitute for the material we ordinarily require because materials change and get better over time. And if you can show that this is the equivalent, then we're fine with it. Maybe you deny it for reasons that it's too close to the setback line. But if you can show that you can do it all within the setbacks, we're going to do it. But if you deny, you're always better off denying with some suggestions or reasons. Maybe it's we're denying because we don't think that it meets the aesthetic qualities of the community. The colors are too bright or too muted, whatever the case may be. The roof line is too high. The orientation of everything is the wrong direction, whatever. Then you give the reasons or suggestions as to why it wasn't allowed. Suggestions maybe if you do this, we'll approve it, but we're denying it as you're requesting. And then what happens after that? Well, if the owner is if the owner's unhappy, what do you do next? And I'm a big fan of appealing to the board. Now, this is a only applicable if you have an ARC that is not the board. The board is not acting as the ARC because you're not going to be able to appeal it. But if you have an independent ARC, then I allow appeals to board. In fact, I just went to a mediation this week. Happened to be a Washington association I represent up in Vancouver, but they have we went to mediation with a retired judge acting as the mediator over an addition and a view restriction issue. And we had to sit in a mediation trying to resolve a dispute between two homeowners, two different homeowners and the association over the view, and it was an architectural review issue. It had been reviewed by the ARC. The ARC had decided it. It had been appealed to the board because their documents allow for that. The board actually upheld the architectural review committee's decision, and then the owner was threatening to sue, and they have a mandatory mediation clause before an owner can sue the HOA. So we went to mediation and had to go in there and try to resolve it in mediation. So that's kind of the structure of the process and how it works. Now, I see some questions in here, and I will go through these really fast, and then we can, if there are any other questions about this process, we can take them as well. You can just use the hand raise function on there. Okay, our documents say anything over $500 for improvements, alterations, or additions. So just about everything comes to the ARC. I mean, that's the way it should be. The ARC should have control over essentially any alteration, except within the interior. In a condo, frankly, condominium ARCs are not as busy. There's not as much to do for them because nobody should be touching the outside of the condo. It's really only structural issues and noise issues on the inside. Now, what I don't want you to confuse, and I'm not saying that Jackie's question about this or statement is wrong because I don't know what her documents say, but oftentimes there is a provision that says any alteration or improvement or addition over a certain amount of money, $500 or $1,000 needs to be the association needs to be made aware of it. It's not tied to the application. It just says it needs to be made aware of it. And this is particularly true in your condos. And you find that provision actually in the insurance section because it's an insurance requirement. And that's different. So it may be insurance related. And so be careful as you look at your own documents. Each set of documents is different. It may be an insurance requirement as opposed to an architectural review requirement. In Jackie's case, it looks like they also have a monetary limit. So if I go out and I put pavers in my yard and it's less than $500, I don't need to get ARC approval. But if it's more than $500, I do. And I'm not really a fan of those because prices change over time, and that $500, the value of that is very different as time changes. But the other problem I have with it is it allows simple projects that, and I see this cutting both ways, but it allows simple projects to a yard without the aesthetic control over it. It may look really garish. It may look horrible. And yet it's under $500. And so the ARC doesn't have the authority to deal with it. And I'm not a fan of that. I think the ARC is controlling aesthetics. Curb appeal is a real thing, and no, we're not all going to agree on what looks good or not, but I think everything should run through the ARC. So that's a very interesting provision, Jackie, and thank you for the comment. All right, so there was another question about from Linda about the laws that are in effect, and it's the Oregon Plan Community Act or the Condo Act, depending on what kind of community you are. The planned community is ORS Chapter 94. The condo is ORS Chapter 100. And there is a little bit on architectural review in there, but frankly, most of it is going to be driven by your governing documents. So it's your governing documents that are going to drive the architectural review process and how decisions are made, and what has to come before the ARC, how that all plays out. That's not found in the statute. That's going to be found in your governing documents. All right, I want to go back to the next, if I can. There we go. All right, this next slide, and I know we talked briefly about it a few minutes ago, but I want to reiterate this. How are decisions made? Committee, this is important. Committee reviews for conformity with the architectural rules. So your documents will say if you can make variances or not. if your documents don't allow a variance from the architectural rule. So let's say the CC&R say no pink houses. The ARC cannot come in and say, well, we're going to let you have a pale pink house or a more of a mauve house, you know, it's a little red and pink mix. We're not going to allow you to do that, or we're going to allow you to do that because we think it looks good. It doesn't look bad. Well, the ARC doesn't have the authority to do that. They have to comply with the guidelines and with what the declaration says, unless the declaration says the ARC has the ability to make variances in specific situations for whatever purpose. But if you're going to make variances, you need to be consistent in that. You can't treat people differently. You can treat people differently based on factors like, well, the location of your house right in the center of the neighborhood, it's not going to look as good as it would in a back corner of the neighborhood where it's hidden. Or, you know, the fencing on your yard, because your yard is elevated and hilly, you know, a 6-foot fence that slopes down is very different than a 6-foot fence on a flat yard. And so we'll let them go to 7 feet, but not you, because of it. You have to be careful on that. You have to look at factors and treat people similarly. Although if your documents give you the variance authority, you can do it. This is what I was talking about earlier, the legal standard, the Valenti case out of Deschutes County, you know, fraud, bad faith, or failure to exercise honest judgment. That's the standard. And they're going to defer to you if you follow that standard. And then again, we talked about the meetings and whether you had to allow the owner to be present or whether decisions have to be made in an open meeting. I am always a fan of allowing the owner present at the meeting because it's their home, the owner's home that's at play. And in my opinion, they ought to be able to see how the ARC is deliberating, see what the concerns are, and see if you can work it out. It ought to be an interactive process. And sometimes it's very simple. You know what? We're not allowing that paint color. It's not in the palette that we have. We're not going to allow it. Or we're not going to allow that roofing material because it's not the type of style that we allow. But other times it's more nuanced. The decision is more nuanced. Well, we have concerns about this drainage. We have concerns about this grading. And, you know, how can we solve this problem? What can you do? And that's part of the discussion that the owner should be in. All right. I've been prattling on for about 35 minutes or so. Are there any other questions on this process? Anything that you want to ask me about the process in and of itself? None, huh? Okay, very good. Well, I apparently have either done a good job of explaining it all or confusing people. But remember, it is a process and you need to follow the process. And if the process is not laid out in your declaration or in your bylaws, then you need to create guidelines that lay the process out. And next time our discussion is about the guidelines. And so I will have a blacked out set of guidelines, again, to protect the innocent, that you can see that has both good and bad, because there's never going to be one perfect set of guidelines, but so that you can see as an example of what people do. And we'll talk about how to make that work, how to
Hey, Chris.
Use it. Yes, Audrey.
I think Karina has her hand up. Karina, if you want to unmute yourself if you do have a question.
Sure. I just something just occurred to me kind of while you were wrapping up there. So with regard to appeals, if we have the ARC has made a decision, they've given a report with conditions, the owner received their approval letter and proceeded to paint. And now 9 months later, the ARC went and looked over it and said, well, that's not quite what we thought was going to happen, or our conditional approval was that we approve the palette. I'll clarify in a minute. So then she appealed to the board. Well, I got my approval letter and I painted, and the board said, we don't feel like we're going to pursue this. And then after the meeting, I think the ARC was like concerned about the precedent that it sets because it's not on the approved color palette. And so now they were discussing what to do. Could they make her paint the trim after she's appealed and they've decided not to pursue it with her? Can they go back to her basically after they have overruled the appeal?
Well, not usually. It depends on how the documents are written. But if the documents are written that says the ARC makes a decision and then an owner can appeal that decision to the board, then the board's decision ultimately is going to be final. And that's where it often times gets interesting between the board and the ARC, because they get in disagreements, I guess is the politest way to say it, over a ruling sometimes. But once it gets appealed to the board, it's out of the ARC's hands. Now, what's interesting though, Karina, about the one that you just raised is it sounds like the ARC had approved the paint color originally. Is that accurate?
They said, subject to the following special conditions, the trim and shutter colors be confirmed by the ARC through CMI to match the architectural pattern book specs before painting begins.
Okay, and did they do that?
Well, I suppose the ARC didn't do that because they handed her that letter and off she went to paint because she didn't.
Did she handle the letter? Did they hand her the letter saying you cannot paint until this happens, or was it not written quite as clearly?
No, it was written as your project is approved with these conditions, and then nobody followed up.
Okay, so at that point, if I'm the homeowner, I'm going to say that's on you, ARC. You didn't follow up. You didn't do your job.
That's what I told the board.
And if you don't do your job and you approve it, whether it's a blanket approval or an approval with conditions, but the conditions are satisfied or the conditions on you, then it's on you. This actually highlights a really great point, Karina. When you make conditions, whether you're doing it as an ARC or as a board, very rarely do you make conditions on yourself. The conditions ought to be on the homeowner, things they have to do, because if it's on you, then what you need to do is get more time so that you can do your due diligence and make sure that that color palette is what you want, make sure that that material is what you want. Because once you give the approval with a condition, the owner's going to read that as, okay, I'm ready to go. And you're hurting yourself. And it sounds like in Karina's case, this is what happened.
Yeah, the owner did her due diligence in trying to find a palette that was adjacent to the existing palette. She just wanted something, I think, a little bit lighter. So she went and I mean, she did do a considerable amount of work and consulted an interior designer and said, would this work? Went to the parent colors and then extrapolated out, adjacent, lighter tones of the same family type thing. So, she was pretty thoughtful in her approach. Of course, now they're in a situation where another owner goes, ooh, I like that. And I want to paint my house that color, but it's not technically on the approved palette, even though they've sort of backed themselves into a corner about it. So we'll see what the board does. I mean, they made their decision in an open meeting. So I don't know what the owner will do as far as push back, but maybe she'll lawyer up. Who knows?
So which owner are you talking about? The owner that
owner that painted her house. I think what they're going to try and get her to do is just paint the trim a different color to make it more compliant, but I don't know how that'll go.
All right. Yeah, that's always very interesting. And it's architectural review is an area that can breed great fighting and hurt feelings in a community. And that's why I think engaging the owner in the process throughout is the best way. And like I said earlier, at times you're not all going to agree, and there are going to be decisions that people don't like, But if you follow a standard process and you treat people with respect along the way, you mitigate that as much as you can. So very, very good. Thank you for sharing that, Karina.